Welcome, ladies and gentlemen, to part 2 of 3 lessons about civil liberties. My name is Miss Jennifer Blank, and I will be your guide on this journey. Let's start out with some key vocab. As you can see, there's a lot to cover here. I want you to pay particular attention to the Supreme Court cases, New York Times v. Sullivan, Miranda v. Arizona, Mapp v. Ohio, Engel v. Vitale, and Roe v. Wade are particularly important. Lawrence v. Texas deals with homosexuality, and we will get to those right quick. All right, so what is libel? Libel is written defamation of character. Slander is spoken defamation of character. There's a higher standard for libel. Public figures must meet higher standards than ordinary people to win a libel suit. So if you're a public figure, you're a senator, and you're suing somebody for damaging your character, there's a much higher burden that you need to meet in order to win that lawsuit. Public figures put themselves out there on purpose, and as such, they need to acquiesce. They need to accept certain consequences of putting yourself in the public eye like that. In New York Times v. Sullivan, this case established that actual malice must take place to prove libel. So you actually have to prove that a person was actively trying to hurt you in order to prove libel. So this ruling makes it a lot more difficult for public figures to win those lawsuits. As I said, slander is spoken defamation of character. Now, free press versus a free trial. Last lesson, we talked about freedom of expression, freedom of the press, freedom of speech, things of that nature. Now we're going to talk about that freedom of the press versus due process rights, freedom of the accused, or freedoms and protections of the accused. There are these things called gag orders, and sometimes judges will issue these in an effort to protect the right of a defendant to a fair trial, because this right supersedes the right of the public to attend or be in the know. Court does permit the press to publish factual information, however. Now, you see 3 Supreme Court cases listed there. This was an evolution of the court's view on free press versus free trial. So in Nebraska, it says the court rules that gag orders violate the guarantee of the freedom of the press. So gag orders are a no-go. Then in Gannett, the court rules that members of the public don't have a constitutional right to attend criminal trials. It's not about the public, it's about the person under trial, the person who's been arrested. And then in Richmond in 1980, and this evolution happened very quickly. In Richmond, the court rules that actual trials must be open to the public, but certain unusual circumstances can prevent this from happening. And the other concept behind a gag order is to make sure that the jury pool is not corrupted. It is not polluted, because if a lot of information is released before jury selection occurs, then the public is predisposed to a certain viewpoint, potentially, and that would violate the right of a fair trial of the accused. All right, so now that we've talked about free press versus the rights of the accused, let's talk about what precisely the rights of the accused are. Now, there are some key amendments we're going to look at here that are very, very important, that detail if you're accused of a crime, this is what you have a right to. No unreasonable or unwarranted search or seizure. You can't be arrested unless there's probable cause for your arrest. There has to be a reasonable cause and evidence in place in order to arrest you. The Fifth Amendment says there cannot be coerced confessions, and you can't be forced to incriminate yourself. So if you are forced to take the stand, the attorney cannot make you answer questions that might incriminate you, that might result in an arrest. They cannot force you to do that. And also, defendants do not have to take the stand in their own defense to prevent compulsory self-incriminations. I plead the Fifth. That's where that comes from. Sixth Amendment says everybody gets legal counsel. You must be informed of your charges, and that those 2 things are involved in Miranda rights, which we'll talk about in a minute. You have the right to a speedy and public jury trial and impartial jury by one's peers. All right, the Eighth Amendment says reasonable bail must be set, and you are not to endure cruel or unusual punishment that is unconstitutional. So, let's look at Miranda v. Arizona. Essential, important Supreme Court case, especially my AP kids. You've got to pay attention to this. Suspects must be informed of their rights by police before they can be arrested or questioned if they are a suspect. Now, if you're not a suspect, they don't have to Mirandize you. If they don't think you're a suspect and they're just talking to you like any other witness, they do not have to Mirandize you. If you are dumb enough to say something that incriminates you, well, they can use it in court. So you have to be careful. But if you are a suspect or they want to arrest arrest you, they must Mirandize you. There are exceptions to the Miranda rule in the cases of public safety. That sometimes this rule can be, you can forego this rule, but other evidence has to be strong, and suspects must claim their rights unequivocally. Now, video recording of interrogations has been a hot topic. They are admissible in many cases, but the procedure has to be precise. And for our purposes, we don't need to know all the ins and outs of that, but if you're going into law, you're going to need to know that stuff. The exclusionary rule is far more important for our purposes, and the exclusionary rule forbids the admission of illegally seized evidence. So if the cops don't have are going into your house and they know they don't have a warrant, and they go in there and they find evidence that you're guilty of a crime, it can't be used against you in court because they seized the evidence illegally. All right. Now, there is a good faith exclusion. If an officer acts appropriately and lawfully, and they've been given a search warrant that is official as far as they're concerned, but in actuality the warrant was invalid, then in that instance, the good faith exclusion applies, and some of that evidence can be entered in at trial. Now, let's go back and talk about more issues involving the press. Film, radio, and TV is complicated because originally our Constitution was designed to protect written press, right? Because that's all there was, or speaking, making a speech. But now that we have TV, we have film, we have radio, and now we have the internet even, the Constitution doesn't speak about that because those things, of course, didn't exist when our founders produced it. So our government has taken a bit more creative license in regulating those things than they can with the press because it's pretty straightforward in the Constitution. They can with the written press. In 1934, the Federal Communications Commission, the FCC, was established to regulate these things: films, radio, TV, internet. The FCC grants licenses and imposes regulations on broadcasting. Now, the internet changes so quickly and has advanced so much in such a short period of time that our regulations haven't quite caught up with the advancements in the internet and with computers. But there's a big debate about this issue called net neutrality. You should look that up. We're going to be discussing that in class in some detail, but we're still having this debate over how much the federal government is allowed to regulate the broadcast media and the internet. Let's move our discussion to the ability of the government to legislate morality and how far that ability extends. A useful place to start would be the discussion of sexual speech, because this is a hot button issue that virtually everyone has an opinion about. Sexual speech is difficult to define. It's language that falls short of obscenity, and according to the Supreme Court, obscenity is not covered by the First Amendment. It is not protected speech because it has no redeeming social political value. Thus, it can be regulated by the government however the government wants. For example, the FCC can forbid radio and television stations from broadcasting certain sexual language and situations, and they can also forbid indecent material on radio and non-cable TV between 6 a.m. and 10 p.m. Now that we've talked a little bit about what the FCC can and can't do, let's talk about this issue of separation of church and state. I mentioned this in the first lesson, and this involves religious freedom. It's the Establishment Clause of the First Amendment. We have freedom from, but also freedom of religion. So there are several issues that fall under this umbrella of the Establishment Clause and this wall of separation. We have aid to church-related schools, the issue of school vouchers, the issue of school prayer, Anglo Vitale, AP kids, pay close attention to this. This is very important. Anglo Vitale, a prayer outside the classroom, the use of the Ten Commandments by government, teaching evolution versus intelligent design, creationism, and religious speech. These have been perennial issues in our nation, and we still hotly debate these issues to this very day. So, in the past, the government has prohibited immoral acts, and it does depend on the values of the time. Prohibition is probably the most well-known example. We became a dry nation for quite some time because people believed that alcohol, many people, believed that alcohol was immoral. So we enshrined that immorality into the Constitution. We ended up overturning that amendment with a later amendment. It was 2 amendments later. But there are instances of government actually legislating morality. Recent major moral policy issues that have been affected by the Supreme Court, however, are a little bit more complex, and we haven't really settled these issues, at least not in a cultural sense. Abortion has been a hot-button issue, homosexuality, and, of course, pornography and censorship. These are hot-button issues that our society is still grappling with and trying to decide how far does freedom of expression and free speech extend? How far do those things extend? And at what point should the government step in to provide for the general welfare, i.e., regulating the morality to an extent of the populace? This is a debate. It's a big one. Privacy rights. Now, privacy rights factor into this abortion debate and the contraceptive debate. There's no explicit constitutional right to privacy, but that right is an interpretation by the Supreme Court. The court has stated that the First, Third, Fourth, Fifth, Ninth, and 14th Amendments imply zones of privacy. Therefore, people have a right to access contraceptives, and women have a right to an abortion. Now, the debate is still going on. Like I said, there's a huge hot button issue here. It's tons of controversy generated by Roe v. Wade. It is a major campaign issue, but state abortion restrictions are often supported by recent Supreme Court. So the debate isn't over. It depending on who's on the court and how they interpret the Constitution, whether they have a strict or loose interpretation of the Constitution, is going to determine how they rule. And we have by no means settled this debate. I'd like to leave you with a couple of political cartoons here. Some of them may be hard to see. The one over here on the top right, you see the Democratic donkey on the left, and then the Republican elephant on the right. The donkey is calling the elephant a hypocrite with their high moral standards that the Republican elephant has knocked over, yet the moral standards of the Democrats are so low. So this is basically a pot shot at both parties. And moving to the right, there's a picture of a church, there's a wall, then there's the state on the other side, and there's a few folks, and the church folks have come on over the state side and saying, you'd better stay on your side of the wall. And then down below here on the bottom left, there's a pharmacy. The pharmacist says, sorry, I'm morally opposed to you filling your birth control prescription. But your boyfriend there looks like he could stand a dose of Viagra. So there's another political cartoon depicting some morality. And then over here on the bottom right, the moral high ground is the question that's posed. On the left, you see someone looking pretty conservative, and they're standing on top of a hill, and they're holding a gun, and there's gravestones for fascism, the Nazis, British Empire, communism, home invasions. And then on the right-hand side, you have a person representing a liberal. Guns kill people, and then you see the word abortion, and then tons of little crosses. So I'll leave it to you to interpret these cartoons in your own way, but just I wanted to give you an overview, just kind of a representative sample of the types of feelings that are out there, the types of opinions that are out there. And so I hope this widened your knowledge of civil liberties, and I will see you very soon for part 3.